Hey, what's up? Everybody, welcome back to the channel. Today, we're diving back into the wild world of real estate contracts with part 2 of our series. If you haven't seen part 1, make sure to check that out first. I'll link it up here and in the description below. In the last video, we covered the basics, the stuff everyone needs to know before even thinking about signing on that dotted line. But trust me, there's way more to it. Today, we're getting into the nitty-gritty, the essential clauses and concepts that can make or break a deal. We're talking voidable versus unenforceable contracts. What happens when someone breaches a contract and how you can protect yourself. This is the kind of stuff they don't teach you in those get-rich-quick real estate seminars. All right, let's break down these two confusing concepts. Voidable and unenforceable contracts. Now, a voidable contract might sound bad, but it just means one party has the option to back out without any penalty. Think of it like a get-out-of-jail-free card. Say you're buying a house and later discover the seller wasn't entirely truthful about the property's condition that could make the contract voidable on your end. On the flip side, an unenforceable contract is basically useless in a court of law. This could happen if the contract is missing key elements like a signature or if it violates the statute of frauds, which we'll get into later. Imagine trying to enforce a verbal agreement for a piece of land. Good luck with that. Okay, so what happens when someone doesn't hold up their end of the bargain? That's a breach of contract, my friends. Let's say a buyer backs out for no valid reason. That's a breach. Or maybe a seller decides to sell to someone else at the last minute. Another classic breach. Now, if a breach does occur, there are a few ways it can shake out. You might be able to terminate the contract altogether, essentially hitting the reset button. Another option is rescission, which is like the contract never existed. And of course, there's always the possibility of suing for damages. We'll cover that next. When it comes to real estate contract disputes, understanding the different types of damages is crucial. First up, we have liquidated damages. These are predetermined amounts agreed upon in the contract itself, usually the earnest money deposit. It's like a safety net for the seller if the buyer backs out. Then there's compensatory damages, which aim to cover actual losses caused by the breach. Did the breach cost you money, time? Compensatory damages are all about making you whole again. And finally, we have punitive damages. These are less common and are intended to punish the breaching party for particularly egregious behavior. Listen, we live in a digital age, and the real estate world is no exception. Electronic contracts and digital signatures are becoming increasingly common, and for good reason. They're convenient, efficient, and just make life easier. But before you ditch the pen and paper entirely, it's important to understand the legal requirements in your state. Make sure those e-signatures hold up in court. In most cases, electronic contracts are just as legally binding as their paper counterparts, but it never hurts to double-check. Okay, I know statute of fraud sounds intimidating, but it's actually a pretty simple concept. Basically, it's a law that requires certain contracts, including most real estate contracts, to be in writing to be enforceable. Why? To prevent fraud, of course. Think about it. A handshake agreement for $1 million property sounds like a recipe for disaster. The statute of frauds helps protect everyone involved by making sure the terms of the agreement are clear and documented. Ever seen that phrase, time is of the essence, in a contract? It might seem like standard legal jargon, but trust me, it carries serious weight. Basically, it means deadlines are critical, and any delays could be considered a breach of contract. So, if you're buying a house and the contract says time is of the essence, you better hit those inspection deadlines, financing deadlines, and closing dates. Otherwise, you could risk losing the deal altogether. Negotiating a real estate deal is a bit like a dance. It's all about finding that sweet spot where both parties feel good. It usually starts with an offer, which outlines the buyer's proposed terms like the purchase price, closing date, and any contingencies. Now, the seller can either accept the offer outright or they can counteroffer, changing some of those terms. This back and forth can go on for a while, but eventually you'll either reach an agreement or decide to walk away. When you make an offer on a property, you'll typically put down a deposit called earnest money. This shows the seller you're serious about the deal and acts as a form of security. Now, if you back out for a valid reason, you usually get your earnest money back. But if you breach the contract without a good excuse, those funds could be considered liquidated damages. Remember those from earlier? The seller might be entitled to keep that earnest money as compensation for their troubles. That's it for part 2 of Real Estate Contract 101. We covered a ton of ground today, from voidable contracts to the statute of frauds. Remember, knowledge is power, and understanding these concepts is crucial for any real estate professional. If you found this video helpful, hit that like button and subscribe to the channel for more real estate tips, tricks, and strategies. And don't forget to ring that notification bell so you don't miss out on future uploads. Thanks for watching, and I'll catch you in the next video.